So earlier on the programme, we heard from the Taoiseach and Minister for Foreign Affairs, Micheál Martin, on why he is advocating for yes, yes in Friday's double referendum vote. Well, Peadar Tóibín is the leader of Aontú and he's on the line, and Peadar is campaigning for people to vote no and no. Good morning, Peadar.
Good morning, Claire.
So earlier the Taoiseach was saying that the confusion that has developed around these referendums, people saying, I don't really know what I'm being asked. He said that confusion has been created by the no-no campaign, by people like you, that you're creating doomsday scenarios that will never come to pass. What do you say?
Well, the simple solution to that would be for Micheál Martin just to be able to give a definition to people that is constitutionally clear so that people know what they're voting for on Friday. I think people should have a right to know what they're voting for in a constitutional referendum, and the government cannot define that. So, I asked Thomas Byrne, can a person be in a marriage to one person and be in a constitutionally recognised marriage equivalent relationship with another person at the same time? And Thomas Byrne said yes. And, obviously that is a recipe for chaos in terms of, wills, social welfare, taxation, immigration, family law. Roger O'Gorman was asked the same question, and he wouldn't answer yes or no, but he said it would depend on the magnitude of the durable relationship. So he was introducing the idea that durable relationships have different magnitudes in the Constitution. And the Taoiseach was stated that marriage will be able to be prioritised in future, even if this passes, while Roger O'Gorman in the Seanad said, no, he doesn't agree with that. So even the government...
He says today, you're overcomplicating this, because a durable relationship, it's clearly a lasting relationship with commitment.
So first of all, mostly when we talk about the Constitution, the words exist in the Constitution are words that are understood either through definition within the Constitution or law or through jurisprudence. This is one of the few examples where people are being asked to put in a term where there's no definition at all. And the only definition that actually exists in previous cases is the case where a durable relationship is understood to be an intimate or a sexual relationship between two people. And that's clearly not going to then cover families that are headed by a single-parent family. So the government, I think, through incompetency, have created this incredible situation that 2 days before people go to the polls, they still can't give a definition. They can't say, a durable relationship starts after 6 months or a year. How do people know when they can achieve their rights in a durable relationship? Will they have to go to court? Are they going to spend thousands of euros going to court to achieve their rights? It's an incredible situation. And,
Micheál Martin said earlier that, it would be more of an issue if they were deleting all articles, Peadar, pertaining to the family, because the Constitution says on multiple occasions that the family is the moral institution. Does that not provide more guarantees and more clarity?
Well, see, the problem is, again, the government say that marriage will be prioritised in the future, but then they say that all families are exactly equal. And you cannot have both the same situation. So what happens for example, to a farming family? If one person is in a marriage with one individual and in a durable relationship with a separate individual at the same time, what happens to whether or not where that farm is left or where that house is left? In a divorce situation... Does the
succession law not deal with those issues already?
But just in a divorce situation or a civil partnership, you have to bring one relationship to a close and provide for all the participants of that relationship before you can proceed to another. You won't have to do that in this case. And, succession law does define how wills are created, but it has to be in sympathy with the Constitution. The Constitution trumps that. So this is a paradise for solicitors and lawyers into the future, because so many cases are going to come before the courts to try and work out what this situation means. And, we'll have to go back and have another referendum if we want to clear up this mistake. And, we saw, in the marriage referendum, people were very clear what marriage meant. In the abortion referendum, people were very clear in terms of what abortion meant. But nobody is clear in relation to this, and that is the responsibility of the government.
Can I ask you about the carers element of this? Because Micheál Martin said the state has involvement in home care and how that sector has been funded to date. He says that this proves that it will do more if it has to for the ageing population, and we know many of that population, that cohort, would like to live at home for longer. What is your response to that?
Yeah, well, I think we've reached peak virtue signalling at the moment in this country. There's such a chasm between the marketing language of the government and the real experiences of people. This particular amendment puts a ceiling on the government's responsibility to provide care to families.
Where's the ceiling, though, in this language that the state will strive to support people who are caring? There's no ceiling on the word strive, is there?
There's two elements. Strive means to try. Obligation means they have a responsibility. So this came from the Citizens' Assembly with the terminology obligation. And the government, with their neoliberal instincts and their Department of Finance defence of budgets, decided, whoa, we're not going to get into a situation where we're obliged to help people. We'll water it down to get to a situation where we'll have to try. And try can be mitigated, obviously, with lots of other arguments in terms of that. Care has never been as devalued. Most people, and this is why the government are in trouble in this amendment, because so many people know what it is to struggle to try and achieve government support in terms of care, whether it's a parent with a child with autism trying to get the necessary supports in relation to that, or an individual with a parent who has Alzheimer's, or a child with a disability. The government have been really poor in providing services to people who need them at the moment. And what they're saying here is care exists within the family, and the responsibility is between family members. And we may strive to help a family member help somebody else. And that's wrong, and it's a kick in the teeth, I think, the carers all around the country.
You're saying it's a missed opportunity as opposed to those carers losing anything that currently exists?
Well, no, the actual article, Judge Susan Denham very clearly states that the article that exists at the moment recognises the significant role played by mothers within the home, and actually states that the state has a responsibility, to protect their choice in whether they work at home or not. And, that is a responsibility that the state has. There's actually, it has been cited in a number of Supreme Court cases already. The Murphy case in 1980, which protected families against the government's income tax laws at the time. The L versus L case in 1992, which protected maintenance and alimony. And there's actually a case before the Supreme Court at the moment where a mother who's, looking for carers allowance, and of course the government are refusing to give her full carers allowance. So she's doing her best to get that carers allowance, and she's citing the current article. And a panel of Supreme Court judges said, yes, there is a case to be heard here. There's a potential for a systemic rights to be achieved here, and it should be heard. But if we vote for the government's carers amendment on Friday, that case falls, and all the opportunity for thousands of people who could potentially achieve rights far into the future as a result of that case falls also.
Father Tóibín, thank you for joining us this morning.